Good afternoon. Happy Tuesday. Welcome back. We missed you last week. We're here today with Matt Grumbling from Win Tarbet, and today he is going to be talking about accessibility online. So, when you think about the ADA and compliance, most of us think of, that's a physical thing. But actually, there's a whole other side, and there is ADA compliancy that is required for the internet. I'm sure a lot of us, we don't know what we don't know, but Matt is going to talk to us about that today. And I think it's going to be very interesting and we're going to learn a lot. Hi, Matt.
Hi, Julie. Well, hopefully we'll learn a lot.
I think we will.
I've learned a lot in the process of preparing this. As Julie mentioned, my name is Matt Grumbling. Here's my name and my email, my cell number up here at the top. You can email me. You can text me. If you do text me, just identify yourself so I know I'm not just getting a random text from somebody. I'm with NTIP Law. It's hard for some people to say win. It's just like win with an N at the beginning. So if you think about winning, it's just winning. Win and Tarbet. We do mostly patent and trademark law. We are branching out a little bit. I think with the changes in the economy and whatnot, everybody's diversifying to a certain degree. And the ADA and the internet is a growing area of law. You might be surprised. I was surprised to learn this. I have a good friend who is in the ADA compliance space. He does the brick and mortar type of things, and he's been doing that since the last downturn. So, and he had made me aware of the ADA and how it applied to brick and mortar type of stores, and I've since learned more about that. But I was surprised to learn that the ADA also applies to the internet, and not in the way you might hope or think. So we'll go over that a little bit, and toward the end, I'll give you a little bit to think about in terms of just the price tag that can attach to these types of things. So I'm just going to kind of encapsulate accessibility online with two things. I'm going to go through a short refresher on the Americans with Disabilities Act, and just going to recap a little bit about what we learned in the first few sessions. And then we're going to go on and look at this kind of word salad of the W3C, the WCAG, and the ADA in the internet age. And then I'm going to give you just a flavor of some exemplary lawsuits. There have been, you're going to see this may shock you when you see it. So let's just go through our ADA refresher really quickly. The ADA was adopted in 1990. If you were around back then, you might remember it was championed by Senator Bob Dole. And he had famously been severely injured in World War II. And he, despite the fact that he was an extremely energetic guy and never seemed to miss a beat, he actually had a severe disability himself. And so he championed this ADA through Congress, and it was finally adopted in 1990, kind of right in the middle of the first George Bush's presidency. It was passed as an Equal Opportunity Act. It was modeled after the Civil Rights Act of 1964 and the Rehabilitations Act of 1973. It protects those who have a disability or have a history or a record of disability or are perceived by others as having a disability. And I think part of the reason they threw that in there is because, you may not consider the situation, your physical situation or your mental situation to be a disability, but others may, and you may be discriminated against on that basis. And the ADA is supposed to prohibit that. So a disability is defined as a physical or mental impairment that substantially limits one or more major life activities. We have narrowed our focus here in this down to Title III. Title II actually applies to state and local governments. Title I applies to employment. We've kind of skipped over employment. That's but there are many parallels between Title III and Title I in the sense of what constitutes a disability and what are reasonable accommodations for it. So I think if we concentrate on Title III, we'll hit a lot of the same considerations. The only difference is when we're talking about Title III, we're concentrating on public accommodations, whereas the other two are concentrating on different areas, different groups of, if you will, different groups of defendants, really. So we're going to talk about accessibility on the internet as a public accommodation. You may not have thought of the internet as being a public accommodation. I know it didn't really occur to me before I became aware of this. And actually, I think given the state of affairs right now, I'm not sure anybody in the government really thought about it. This seems to have come about as more of the brainchild of a group of creative litigators than anything else. But it's just one of those interesting things where once a statute is enacted, it can very often morph into something that nobody really anticipated, maybe nobody really intended. Anyhow, now the Department of Justice is supposed to establish regulations and enforce Title II and Title III. Title II, again, being state and local services, Title III being public accommodations. I say supposed to, DOJ has for brick and mortar establishments, but DOJ has not promulgated accessibility rules for the internet. Now, there are two ways you can interpret that. One is that the DOJ, which is, is actually the agency tasked with enforcing the ADA, doesn't think that the ADA applies to the internet. And so you might interpret the law narrowly, just taking the view that, well, if the DOJ, which is that governmental agency that's tasked with enforcing the ADA, hasn't promulgated rules, then there are no rules. And it's just the wild, wild west. A different way of looking at it, and it's the way I think that's been preferred by most of the courts that have looked at this subject, is that, and I would say, that the DOJ, the fact that DOJ hasn't promulgated accessibility rules for the internet contrasts with their comprehensive treatment of physical accessibility under the 2010 ADA standards for acceptable design. And you can also see the guidance on the 210 standards. And you can look at ada.gov to find all of that. There was a notice of proposed rulemaking issued for the internet rules in 2010. And it's now 2021, and no rules have come forth from DOJ. So again, one might infer from that the DOJ doesn't think that the ADA applies to the internet. Excuse me, especially since there's really been no progress on that front since then, at least none that I could find. Well, what the courts have done, and this is what I was getting at before, was that, there are two ways you could look at it. DOJ hasn't spoken. They don't think the ADA applies to the internet. They haven't even issued rules on it, even though they said they were going to start on them back in 2010. It's been 11 years. Well, clearly the DOJ doesn't think it applies. The ADA doesn't apply to the internet. What courts have done is they've looked at it the other way around. And what they've done is they've applied the idea that the ADA is supposed to be a remedial statute. It's supposed to remedy a problem that exists in society, and remedial statutes are generally construed very broadly. They don't have to be, there's no, there's no law, but there is a general, they apply a general canon of statutory interpretation that says that remedial statutes are applied broadly. Well, now, more recently, Congress, and I mean recently, this was at the end of the last Congress, there was a congressional proposal to have DOJ, there's a congressional proposal, I mean, there was a bill, it's actually passed the House, I think it got bogged down in the Senate, and then January 3rd came and that Congress is gone and they had to start over. So that's what happens at the end of every 2 years whenever Congress hasn't passed legislation. Everything that didn't pass dies, has to be resurrected by the next Congress, and they may not even have the same committee chairman, and they may not have the same the same people there to champion various proposals. So it's going to have to start all over again, and the bill goes back in the hopper, it goes to the committee chairs, and then the chairs have to decide what's going to happen. Long story short, it's bogged down. So it could be resurrected, but when, we don't know. In the meantime, the courts have stepped in. And what they have done is they've applied a set of standards developed by a non-governmental agency called the Web Content Accessibility, they have applied so it's a W3C, the World Wide Web Consortium, and they apply the Web Content Accessibility guidelines. So in addition, state laws also may have interstate reach. And two that I know of, and there may be more, but the California Unruh Civil Rights Act and New York's human rights laws have been applied by state courts to apply to the internet. And because of their very broad interpretation of their own jurisdictional statutes, these often end up having interstate effect where you might not expect to see it. And I should also say that federal courts sitting in, say, the Southern District of California or the Northern District of California or the Southern District of New York, they may apply local common law principles to the ADA. They may just take what's called persuasive notice of these interpretations, and they may simply apply them to the ADA. The long and short of it is that federal courts, who are tasked with enforcing the Americans with Disabilities Act, because it's federal law, they have by and large taken the view that the ADA does apply to the internet, and almost universally they have applied these web content accessibility guidelines by the W3C, even though that W3C is not elected. They're not appointed by elected officials. They're sort of an ad hoc committee of whatever industry leaders happen to be out there. And if you're concerned about, large corporations taking over your lives, well, add this to your list of concerns. Now, that's not to say they don't mean well. It's not to say that they don't have the best intentions, but there's no elected official keeping watch over this W3C group, and just keep that in mind. So who's affected by the WCAG? Well, anybody with a disability that can be accommodated with reasonably available technology. You might notice that that's a bit of a moving target, right? And what was reasonably available 2 years ago is probably different from what's reasonably available today. And who decides what reasonable is, and who balances out the costs and whatnot? And the answer to that is, by and large, courts do, because that's who decides what's reasonable, courts and or juries. So you can see that there's a bit of a problem there, because at least in the brick and mortar sense of the ADA, you have very, very clear and specific rules that are promulgated, in terms of what the grade of your parking lot has to be, and the grade of any ramps, and where you have to have handholds, and how far your salt and pepper shakers have to be, or how close they have to be to whoever's trying to reach them, things like that. It's a little more vague in terms of the WCAG, and that causes me a bit of, I don't know, it gives me a bit of the willies. So, and I'm not, and this isn't saying that I don't think that the ADA should apply to the internet. I'm not really opining one way or the other on that. I'm just saying that this is a fairly, this is a moving target to a great degree. In any case, we have auditory, cognitive, neurological, physical, speech, and visual impairments. These are all possible. I think that even though there are more things listed here, I think they pretty much encompass the same kinds of disabilities that, but maybe the one not being here is maybe a movement impairment. Since you're on the internet, movement isn't such a big deal, at least not in terms of, walking or running or something like that. But, the rest of these are pretty much encompassed within the ADA's own definitions of disability. Here's some examples: permanent or temporary loss of a hand. Now, this is another important thing here. In the ADA, really only contemplates permanent disabilities, not like a temporary cast or something like that. The WCAG asks you to look, to foresee the possibility that somebody might only temporarily lose the use of a hand, and want to be able to set some accessibility options on their handheld device or on their computer to be able to work with only one hand. And I think their logic on that is they're the same kind of adaptations no matter what, and you should be prepared for either one of those, either one of those eventualities. It's going to be probably about the same cost to you one way or the other, so you may as well hit both of them. Again, no limited or poor eyesight. So there are different options there for dealing with somebody with poor eyesight, color blindness, loss of hearing, or operation in a loud environment. And there are two different things there. One is loss of hearing, you can't hear at all, or you're operating in a loud environment, and so you're not going to be able to hear whatever it is that maybe it's on a video with a synchronized soundtrack. So what do you need to do to address that? Well, and again, it's worth mentioning here. These aren't the kinds of disabilities that the ADA would operating in a loud environment is not considered a disability under the Americans with Disabilities Act. And yet, and there it is in the WCAG. And, I don't know that anybody's really filed suits based on the ADA claiming operation in a loud environment as a basis for it, but I can't say I've looked at enough cases to know that that's not happening. So again, I think that I think the court's rationale on it is, yeah, maybe this is a broader, maybe the definitions in the WCAG are broader than what the ADA would cover, but that's okay because, well, the courts can sort that out and limit the scope of litigation down to those parts that are covered by the ADA. What should you do? Okay, I've told you you've got a problem here, and you've got the WCAG. What should you do? Well, I think you should familiarize yourself with the W3C, what their requirements are, and you can do that. I've provided the link here. And that's a quick reference. There's a more comprehensive, but the quick reference gives links out to all of the more nitty-gritty detail stuff. So if you follow this link, you'll be able to, and it's, that's a long enough URL for anybody to remember. You can take this. By the way, we'll provide this PowerPoint for download on the website, so you can, so you'll see what that. Or you can just Google W3C, WCAG, quick reference or something like that, and this will pop up. Maybe a better suggestion is to hire a web designer who's familiar with the, with the requirements that the W3C has put out. Between you and me, though, it's one of those things you want to. This is such a quickly evolving area that there are going to be people who hold themselves out as experts who may not be as expert as they think they are. And I'll show you, and I'll give you some justification for that later on. I think you'll see as we go through these slides that having, more than one set of eyes looking at this situation is the better way to go. One way, and we discussed this when we were talking about brick and mortar, how the ADA applies to brick and mortar stores. Having a person with ADA defined disabilities try the website, and maybe more than one, maybe somebody who has an eyesight problem, maybe somebody who's colorblind, somebody who is legally blind, somebody and uses some sort of text reading software, and maybe somebody also who has a hearing impairment, and see how happy they are with the captioning that you've chosen to do, or the signing, or whatever you decide to go along with your videos or something like that. In any case, you're probably going to want to have somebody test drive it with reasonably available software, the kinds of software that are like web readers. Most people who have eyesight difficulties will have some sort of a web reader. There are other things that you can do, but anyhow, having somebody actually test drive it is probably the best way to go, because somebody will tell you that they're an expert. Maybe what do you know, right? So and if you happen to have a disability, then it's probably then you'll probably be the best judge for that particular disability. There are testing tools available as well, and those are great, as far as I know. But again, having real live people check your website, probably the safest thing you can do. If nothing else, they can swear out an affidavit later on that, hey, they have a disability, and they they tried your website and it worked fine. So you've got some evidence to counterbalance a claim of discrimination if that happens to come up at some time. There are also ADA trained auditors. This might be, this is probably better than some other alternatives, but probably more expensive. So you've got to balance out things, and I'll have a little bit more to say about the balancing as we go along through this. And then keep your website up to date to be compatible with available technology. Technology changes. You're gonna, there was a day when every website was basically text only, and might have a little bit of formatting in it that needed to be made a little bit more robust so that it was adaptable and things like that. These days, things are changing so fast. Who knows what the available technology is today, right? So here's some important concepts for the WCAG. First off, there are the WCAG delimitates between techniques which it classifies as sufficient techniques and advisory techniques, and it specifies that techniques are informative. What does that mean? Well, it's in contrast to success criteria, and these determine whether or not you conform with the WCAG. So the techniques they're presented as a way to inform you of techniques that have been found to be sufficient to meet success criteria. Or, the W3C has said that they advise that you use certain techniques to meet the success criteria. But it's the success criteria themselves that determine whether or not you have conformed with the WCAG. So here, let's just go through a few requirements of the WCAG. Okay, you need to provide text alternatives for non-text content, like pictures, like audio, so it can be changed into other forms people need, such as large print, braille, speech, symbols, or simpler language. For instance, and there are all sorts of different types of non-text content. There are controls and input, like just hitting a down arrow button or an enter button or something like that. That's a control. Or being able to type your name into a field, or something like that. And we'll get down to it. There's time-based media. There's CAPTCHA. I'm sure if you've ever logged onto a secure website, they might check to make sure that you're not a bot by using a CAPTCHA. Then there's other non-text content that should be ignored by assistive technology, things like just pure formatting and things like that. So the sufficient techniques should be viewed as a baseline standard, and other techniques may be sufficient if they meet the success criteria. So you're not bound by the sufficient techniques. In fact, if you happen to be a clever person who comes up with a new technique that meets the success criteria, give me a call. Maybe we can patent it. I'm sure there are a number of different ways that you can satisfy the sufficient techniques, but the success criteria, but the sufficient techniques are sort of your baseline for meeting the standards as they are today. So let's just talk a little bit about non-text content. Here's one type. If a short description can serve the same purpose and present the same information, then you can use a short text alternative for non-text content. If a short description cannot serve the same purpose and present the same information, say a chart or diagram, then you need to have short text alternatives that provide a brief description of the non-text content. So, if you've got a pie chart there, you need to have some sort of alternative, and this will be embedded and I can't tell you how to do that. I don't know how to do that technically, but I know that you can embed that in there. I know that now Microsoft Word offers some of that as an option for pictures and charts and diagrams that you can put in alt text, which the user can either hover over or use some sort of a text reader to elucidate that information. If it's a control or accepts user input, it needs to have a text alternative that identifies the purpose of the non-text content. So if you had a button there that says return, there needs to be some other some other way to enter the non-text content. And I'm just going to go through these quickly here. If you've got a CAPTCHA there that is non-text, let's say it's, find all the crosswalks in these 6 pictures here. And well, that's not going to be good if you are colorblind or if you have, very limited eyesight. You're going to have an alternative way of entering that. Time-based media, they break it down into pre-recorded and live, video only, audio, video, etc. There are all sorts of things you can do. You can have text transcripts, you can have captions, you can have sign language interpretation for audio only. For video, you can have an audio description in the synchronized media if it permits that. If it doesn't permit that, then you'll have to have an alternative way of doing that. Let's see, adapt. So let's go into some of the requirements. And these are some of the success criteria. One is that it has to be adaptable. What does it mean to be adaptable? Well, you have to permit change in layout without loss of information. You have to maintain relationships between information and structure. When a sequence influences meaning, maintain a correct reading of the sequence, allow a change in orientation. So like if you change the orientation of your handheld device, it also needs to change. Distinguishable. Again, this is presuming that there's information embedded in non-text. If use of color is important, then you have to find some other way of conveying that information. If if an audio plays for more than 3 seconds, a user can pause or stop the audio. And this applies to every source of audio on the page. So if you pull up a page and it's got 30 embedded videos in it, then then every one of them has to comply. You need to be able to there needs to be contrast or sufficient contrast. There needs to be text resizing, etc. And under operability, you need to have things that you may use a mouse for that require a large amount of manual dexterity. You might need to have, you'll need to have it an alternative that it be keyboard accessible. There needs to be enough time to do these things. So, you don't want pages timing out so fast that somebody who has some sort of a disability isn't able to get all of the information in the appropriate time frame. So and honestly, I'm not sure my bank really is compliant. There are times when I'm trying to put in a password and it'll be like, oh, it took too long. I got to start over. So, you can think about things like that. Then there are seizures and physical reactions. So, and I think they've found that if a page or if something on the page blinks more than 3 times a second, it's more likely to induce seizures. So you need to avoid that. It needs to be navigable. Okay, so you need to be able to get around blocks. You need to have your page titled, and you need to have focus order. You need to have the purpose of a link in context. You need to have the location, and if it's only a link, then you need to be able to discern what its purpose is. You need to have section headings so that people can easily navigate around it. Some of these things may not actually key in on disabilities themselves. And, I'm not saying in any way that all of these are important from the ADA aspect, but all of these are in the WCAG. Then input modalities, pointer gestures, pointer cancellation, label and name, motion actuation, target size. I'm just going to fast forward through these because there's so many of them. I want you to get an idea of how technical all of this is. It has to be understandable, readable. You have to be able to figure out the page and the parts and the language and the unusual words, abbreviations, reading levels, and pronunciation. And it needs to be predictable, and you need to have input assistance. And all these things need to be built into the page so that somebody who's using an appropriate reader or something like that will be able to understand what's going on the page. And, the abbreviations, which might be pretty apparent to somebody without a disability, they need to be explained. You know, you need to have where you can hover over it and get a definition or something like that. And then it has to be robust. And they want it to be forward compatible with, you know, with later arising technology. Honestly, don't know how you do that. Hopefully, whatever standards are adopted in the future will be backward compatible with what you're doing now, but there's no guarantee that that will be the case. And here are some more things, you know, from the robustness standpoint. So I'm going to now go down. I'm going to talk about some of the internet lawsuits. And first, I'm going to give you some interesting statistics. I have the source for these statistics down here at the bottom. I don't vouch for the source, but I'm going to say that my guess is they're pretty close to accurate, you know, within you know, a few percentage points or something like that. In 2016, there were 262 cases. That seems to be the first year that the ADA was applied. And there may have been a couple, 3 in 2015 that sort of opened the door for this kind of thing. But then in 2017, that number at least tripled, almost quadrupled to 814 cases. And then it almost tripled again to 2,314 cases in 2018. 2019, 2,235 cases. I'm not sure how it went last year. I haven't found any statistics on it. If I had to guess, with a huge number of people working at home and using their computers for nearly everything, I'm going to guess that number went up. The only thing that might have caused it to go down is that, you know, a lot of courts were not meeting live. But that doesn't mean that the cases weren't filed, and it doesn't mean that they couldn't progress. It just means that you know, instead of going to court to argue your case, you were likely having a Zoom meeting with the judge. And I know I had a few cases last year where that's exactly what we did. So these are, you know, you can see maybe a plateau here at 2019. I have a feeling that that number went up by a non-trivial amount in 2020, although I don't really have any numbers for that. And you know, probably not the same kind of tripling year to year that you saw here, but maybe, you know, there's no reason that couldn't happen. With COVID, who knows? Everything went crazy last year. So the highest percentage of these was in retail. So if you have and, you know, that shouldn't surprise us too much, because retail is pretty much where you're going to see the highest percentage of ADA claims overall. And really, what do most people do online that is pretty much mission critical to their lives? Yeah, buying stuff on the internet. So that's the highest percentage. And another 25%, a really large chunk of the remainder, was in food service, entertainment and leisure, and travel and hospitality. They shake out to be nearly 10% food service, a little bit less than 10% entertainment and leisure, and the rest being hospitality. So that's just to give you an idea. You know, if you happen to be in any of those areas, you know, you might want to think about how accessible is my webpage. Yeah, it looks beautiful. It's laid out beautifully, but if I have pictures, do I have alt text descriptions that are suitable for the internet? If I have video or audio, do I have captions and et cetera, or transcripts? So let me just go over a few of these exemplary ADA computer lawsuits. And I'm not going to go into any details on them. I'm just going to tell you who's been sued. So, and for what. So in general, so blind, eyesight impaired plaintiffs have filed against the Golden State Warriors, Domino's Pizza, Winn-Dixie, Five Guys Burgers and Fries, Nike, and Beyonce. And, you know, that, and again, that's just a small sample of over, almost 5,000 lawsuits that have been filed in the last 5 years. And these are probably, I would say, from unscientifically, I would say most of the complaints are filed in this area by or by these types of plaintiffs. Deaf and hearing impaired, the defendants include Netflix. Well, let me go back up. Netflix. Well, again, this is an unscientific study here, right? So, but I think this might be a really this might be an exaggerated representation of the way things shake out, but it seems that the plaintiffs tend to be blind or eyesight impaired, and to a lesser degree, deaf or hearing impaired. And you can perhaps imagine why. When you think about who's going to have a difficult time navigating a website, which is, most of the time text-based. And I'll tell you, most of these seem to be filed by somebody who tried to use a text reading software to read through somebody's, and I won't pick out any of these specific ones because I don't know that it applies to any of them specifically, but the cases I've looked at, it seems to be somebody who has an eyesight impairment of some sort, or is legally blind, goes on a website and is unable to navigate it because it doesn't comply with the software they're using to read that particular website. And what this tells me is, despite, I'm sure, the sophistication of the website designers, that these various, look at these are not, most of these are not really small players by any stretch of the imagination. Despite their sophistication, they managed to design websites that somebody's web reader isn't able to read. Now, I haven't looked into the merits of these lawsuits, so I can't tell you whether these are meritorious lawsuits or not. But the fact that they're being filed should give you pause. So that's so if I were to tell you what to spend your money on, I would say make sure that your website is compatible with the most commonly available types of web readers. And I don't think you need to do anything exotic here, but I think you need to have, to comply with the eyesight and blindness aspect. I think you need to at least make sure that all the text can be read by your, pick your top 3 or top 4 web readers out there. Make sure, and if you can't do it personally, either find friends who have that kind of software already installed on their computers, or hire an auditor who can do that. And make sure that they can navigate your entire website using those web readers. If we look at the deaf and hearing impaired, I think what you want to do is make sure that you've got, if it's pre-recorded, that you have transcripts or you have some sort of captioning so that they can, so they can keep along with, say, dialogue and things like that. And at the very least, if it's not video, if it's, let's say, pictures or something like that, you have alt text defined in there in a way that they can easily read it. So that's all I've got for today, Julie. Again, thanks everybody. Again, here's my name, my email address in case you didn't catch it before, and my cell number.
And thank you. That's a lot to digest. So many things that, you know, the average consumer, I'm thinking, doesn't even think about when you're building your website. You're really relying on your website designer to know that stuff. So it's a good read. It's a good presentation. Thank you. If anyone has any more in-depth questions, you know, as Matt said, feel free to contact him. If you'd like a copy of this presentation, please email me. I would be happy to send it to you. And we will be back here next week, same time, same place, talking about accessibility audits. Am I correct?
That's correct.
All right. Well, thank you so much, Matt. That was really interesting.
Thank you.
So, well, pardon me?
Always a pleasure.
Have a wonderful afternoon, and we'll see you next week.
All right. Thank you.
Thank you.